This courtroom hearing starts off in a very unusual way. Instead of a normal identification, the defendant begins using complex legal language, claiming to be a third-party intervener and not recognizing the court in a typical manner. Right away, the judge steps in to take control, making it clear that the court will proceed based on official records and identification. But here's where things get interesting. While this case may look chaotic at first, it quickly turns into something unexpected. A key witness fails to appear, and that single moment is about to completely change the outcome of the case. Stay tuned, because what happens next is something you don't see every day in court.
Questions, Mr. Gomez?
Can happen until all parties are identified into the record.
All right, so Mr. Tell me again who you are. Who are you saying
I'm
you
a
are?
non-corporate third-party intervener here by special restrictive visitation and not by general appearance, under duress by the means of threat, coercion, and kidnapping.
Okay. Have you ever been known by the name of, in the past, Lupe Gomez?
Will you state your name for the record, please? And will you order the prosecutor to state his name for the record? And do either one of you have a claim against me?
We do have a claim against you. My name is Raquel West. I'm the judge of the 252nd District Court. This is Mr. Luke Nichols. He's one of the assistant district attorneys in my court. Mr. Radford is here representing you.
Okay.
There's an indictment. There's a motion to quash. Mr. Radford has filed that we're here for today. I'm going to take judicial notice of the court's file, which includes numerous documents, including a indictment, the probable cause affidavit, other identifying information that does identify you as Mr. Lupe Gomez. And I'm going to make the finding at this time that you are, for purposes of this hearing, Lupe Florencio Gomez. And we're going to go forward with the motion to quash. Mr.
What's a motion to suppress?
Motion to suppress. I'm sorry. Let me get that pulled up. I have a motion to quash as well, correct?
Yeah, you do.
Hold on.
I think that's a pro se motion.
Okay, so we're here on Mr. Radford's motion to suppress. Let me find that one. It's okay. I'm looking.
Well, while you're doing that,
Nope, stop talking. Stop talking.
Your foreign agents and registration statement.
My what?
Are you refusing to do so?
I am.
Okay.
Here we go. All right, so Mr. Radford filed, it's entitled Motion to Quash and or Suppress Evidence.
Oh, okay.
And that's why I was confused, because it just showed the first part. And 23 DCCR 0319, this was filed April 29th of 2024. And Mr. Nichols, you may call your first witness with regard to the suppression.
State Calls Officer Chad Morrison.
Would you please call the name?
Officer Chad Morrison. No response, Your Honor.
All right, Mr. Nichols.
Your Honor, I have no other witnesses, and this time for this hearing, the state rests. May I make a statement on the record?
Yes, you may.
Your Honor, I was in contact with Officer Morrison last week. He is formerly of Port Arthur Police Department. He now is with a different agency in the greater Houston area. He indicated he is on injury leave at the moment and would not be appearing for this hearing. He was also on injury leave and was unable to appear last time we were set for this hearing, approximately 2 months.
This is the turning point of the entire case. The prosecution is unable to present its main witness, the officer, who fails to appear in court not once, but multiple times due to injury leave. In legal terms, this creates a serious problem. Without the officer's testimony or any supporting evidence being introduced, the prosecution's case essentially collapses. The judge has very limited options here. Even if there were strong allegations, courts rely on evidence presented during hearings, not assumptions. So when no evidence is provided, the judge is legally required to act accordingly. This raises an important question. Should cases be dismissed purely because a key witness doesn't show up, even if the allegations might be serious?
There's obviously no evidence that would be able to be presented in your case. Mr. Nichols, it looks like, is going to present a dismissal based on the fact that there won't be any evidence, and I'm going to sign that. Your case will be dismissed.
Okay.
You can go back with the
One more
bailiff.
question. The bond money, being that the case has been dismissed, the bond money needs to be returned.
Did you pay a cash
I paid
bond?
cash, $5,000.
But you're back in custody.
You're right. But I still pay the case of this.
Yeah, that you can take that up with the district clerk once you're released. All right.
Maybe excuse Judge.
Yes, if you'll please get me an order, I'm going to make a notation on this, but if you'll send an order.
I'll try to e-file one this afternoon.
All right, thank you. Mr. O'Cleese, when did you smoke pot? Why would you do that when you know you're coming to court for a second-degree felony offense? It's common sense that you're on bond for a felony and you're coming to felony court. No one should have to tell you to follow the law, right? I'm going to raise your bond it is a bond condition that you follow the law. So when you made bond, part of your conditions was that you follow the law.
And just like that, the case takes a dramatic turn. The judge grants the motion to suppress, meaning all key evidence is thrown out due to the lack of testimony. Without evidence, there is no case, and the charges are dismissed. From a legal standpoint, this highlights how critical procedure is in the justice system. It's not just about what allegedly happened, but what can actually be proven in court. However, just when it seems like things are going in the defendant's favor, the situation flips again. The judge immediately shifts focus to the defendant's behavior outside of this case, specifically actions taken while out on bond. And what comes next is a reality check that hits hard.
You can't get a job. How's that going to help your daughter? So you are making mistakes. You're making ridiculous choices. You can go to prison in your case. Don't talk over me. You can go to prison for up to 20 years in this case. And to take a chance while you're out on bond, when you should be trying to get a job, and instead you're out smoking pot, you're not taking care of your daughter. Am I correct?
Judge, if I may, in the past, the court would consider amending his bond conditions for a drug patch in the situation in lieu of raising his bond and putting him back in custody.
Sure.
I'm 27. I've never had any drug charges, anything like that. I'm gonna be honest. I know I shouldn't have been smoking, but in my head, I'm saying, okay, I'm not going for a drug charge. I don't have prior drug charges. I didn't know it was a possibility that I would get to. It's not a problem for me to start smoking. It's not. I could have a tattoo. The bond's been paid on time. I'm not a bad person.
Okay.
I just thought, okay, you're not.
Here's the thing. If you can take care of all those things, then you can also hire a lawyer.
I'm just not working. I could have a tattoo. I just stopped working. Just stopped. Let's say my daughter's 3 months. I was working as a certified surveyor.
So, but there's other companies out there that you could be looking to get a job, and they're not going to take you if you're testing positive. So I'm not saying you're a bad person. Most of the people here that are in front of me aren't bad people. They're people who are making very bad choices, which is what you've done, right? Probably on more than one occasion. So if you don't have a problem doing that, I mean, we've got a couple of things going on here. Number one, if you were working for Zachary, I'm not real sure why I appointed you an attorney back when. Okay. So you should already, if you have all those certifications, there are other companies out there. You don't have criminal history right now. You should be able to get a job. He is already a felon.
Robbery. And I'd like to point out to the court, when he was on probation for that robbery, one of the allegations on his motion to revoke, for which he was revoked and given 10 years, was 2 positive samples, one for tetrahydrocannabinol and all the other for barbiturates. So he at least has some problems with drugs.
July 16. I didn't quite know cases as an adult.
Well, you just said you never had any drug problems.
I never. Just said you said I failed it.
9 years ago, but
I was a baby. I don't remember.
And you've been
Okay, but now you're not a baby and you're still making the same bad decisions. So listen, here's what we're going to do. If you want to really do what you say you can do, then you're going to get out there and you're going to get busy and you're going to do it. Otherwise, you're going to be in jail. Couple things. Your bond conditions are modified to order that you have a drug patch. You get that drug patch within 24 hours. The initial drug patch obviously is going to test positive. but it shows me quantities, not just that it is, but it's going to qualify it on how much is in your system. Every drug patch, you get it changed every 2 weeks. If you miss one, if you test positive, obviously, then you're going to have a warrant for your arrest and you're going to go back to jail. Do you understand? If that amount is not going down, you will be back in custody. In addition, you will go find a job. You will prove to me that you are doing that. You need to apply for at least 3 jobs a week. You need to be applying for 20 jobs a week. If you really want to take care of yourself and your child, then you should be out there hitting the pavement every single day.
Even though the case itself is dismissed, the judge makes it clear that the defendant is not walking away without consequences. Being out on bond comes with strict conditions, and one of the most important is simple: follow the law. The judge calls out the defendant for making poor decisions, including drug use, while facing a serious felony charge that could carry up to 20 years in prison. As a result, the court tightens bond conditions, orders drug monitoring through a patch system, and requires proof of job searching. This moment highlights a broader legal reality. Freedom on bond is not a free pass. It's a responsibility. So what do you think? Was the judge fair in being this strict, even after dismissing the case? Or should the defendant have been given more leniency? If you found this case as intense as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more real courtroom breakdowns.